You said yes. That's it. That's the whole mistake. The officer leaned into your window and asked, "Mind if I take a look in the back?" And you said yes, to be cooperative, to seem like you had nothing to hide. In that single second, you handed over your Fourth Amendment rights, your carry permit, and possibly your permanent right to own a firearm. Not because of anything you were carrying, not because of anything you did wrong, because of one word. Here's what most gun owners believe. Being cooperative at a traffic stop means saying yes. They think refusing a search makes you look guilty. They think full compliance protects them. They've been told since childhood that if you've done nothing wrong, you have nothing to fear. That belief is costing law-abiding gun owners everything. The truth is this. The most cooperative thing you can do at a traffic stop, the thing that actually protects you, your firearms, and your record, is say 5 specific words. Not yes, not a problem. 5 words that are fully backed by the Constitution and that no officer can legally override without a warrant. I'm going to give you those 5 words in this video, but if you don't understand why they work and when to use them, they won't save you. So stay with me. I've spent years breaking down the exact intersection of gun law and constitutional rights, the stuff that doesn't make it into your carry permit class. Today, I'm walking you through 5 things every gun owner needs to know before their next drive. The consent trap, the psychological pressure play, the 5 words themselves, the supervisor strategy, and the 2026 legal shift that is specifically targeting concealed carry holders right now. By the end of this, you'll know exactly what to say, when to say it, and why the law is on your side when you do. Number 1, the consent trap. Let's start with the moment everything goes wrong, and it happens faster than you think. The Fourth Amendment protects you from unreasonable searches. Without a warrant or probable cause, law enforcement cannot legally search your vehicle. That protection is ironclad unless you give it away yourself. And most gun owners give it away without realizing it, because nobody ever sat them down and explained how the system actually works. There is a 1973 Supreme Court ruling called Schneckloth versus Bustamonte, pronounced Schneckloth versus Bustamonte, that still governs traffic stops today. Under that ruling, voluntary consent is a complete, legally binding waiver of your constitutional rights. That means the moment you say sure, go ahead, even casually, even just to seem cooperative, you have handed a federal constitutional right to a stranger on the side of the road. No warrant needed. No probable cause required. Your permission is the only key that unlocks everything in that vehicle, including your firearms. Here's what makes it even more alarming. From the moment an officer says, "Mind if I look," to the moment most people say yes, is on average less than 4 seconds. 4 seconds to waive a constitutional right you spent a lifetime assuming you had. No paperwork, no signature, no formal acknowledgement. Just a casual exchange on the side of a highway, and your Fourth Amendment protection is gone. And here's the part that stuns most gun owners when they hear it. Officers are not legally required to tell you that you can refuse. The system has no obligation to fill that gap in your knowledge. If you don't already know, you can say no, you almost certainly won't. And the law, as it's currently structured, is perfectly fine with that. In states like California, Illinois, and New York, a consented search that turns up an improperly stored firearm or a magazine that's legal in your home state but illegal where you stopped isn't just an embarrassing moment. That's a felony, 2 to 5 years, permanent loss of your gun rights, a record that follows you everywhere for the rest of your life. And even if the search finds nothing at all, the consent you gave is still on record. A history of consented searches can be referenced in future legal proceedings to argue that your later refusals were suspicious or unusual. Every single yes has a paper trail. The fix starts with understanding that cooperation and consent are 2 completely different things. You must cooperate with a lawful stop, pull over, provide your license and registration, respond to lawful identity questions. You are never required to consent to a search. Know that distinction before your next drive, because the officer you're speaking with already knows it. That's the trap. But understanding it isn't enough, because officers don't just ask politely, they're trained to make you feel like you have no choice. And that's where most gun owners get blindsided. Number 2, the psychological pressure play. Law enforcement officers are specifically trained in consent elicitation. That is not an accusation, it is a documented police academy curriculum. Interview techniques, voluntary consent protocols, behavioral compliance strategies, all standard training across departments nationwide. And in 22.6, with body cameras recording every word, these techniques have become more refined, not less. Here are the phrases you need to recognize immediately. You don't have anything illegal in there, do you? I'm just going to take a quick look. It won't take a minute. And the one that works almost every time. If you've got nothing to hide, you won't mind if I look, right? That last phrase is the most psychologically manipulative sentence in law enforcement's toolkit. Studies show that over 70% of people consent to vehicle searches when asked in a casual, non-threatening tone. Not because they're guilty, because they don't want to seem guilty, because they've been conditioned to equate cooperation with full compliance. But here's what that phrase is actually doing. It's framing privacy as evidence of wrongdoing. And that is a fundamentally un-American legal principle. The Fourth Amendment exists precisely because the founders understood that the right to privacy is not a sign of guilt. It is a sign of citizenship. There's a second technique that's subtler. Officers are trained to frame permission as a statement rather than a question. I'm going to take a quick look, not may I take a quick look. That grammatical shift changes your psychological response entirely. A question invites a no. A statement invites passive compliance. And in several court cases, silence in response to that framing has been ruled as consent. In 2006, watch specifically for what's being called the I smell something setup. With marijuana in a legal gray zone across many states, officers in some jurisdictions are citing the odor of marijuana as probable cause, even in states where recreational use is legal, because cross-state transport remains federally illegal. Even if you've never had marijuana in your vehicle, this claim is nearly impossible to challenge roadside. It's being used more frequently post-2024, and gun owners traveling interstate are encountering it at a disproportionate rate. In 2004, a gun owner in Tennessee consented to a quick look during a routine stop. The officer found a legally owned, legally stored handgun, but the driver had crossed into a county with a local ordinance requiring written transport documentation he didn't have. $8,500 in legal fees. 6 months of court appearances. His carry permit was suspended for 14 months pending review. He said yes to be cooperative. He paid for it for over a year. Recognize these phrases for exactly what they are. Trained techniques backed by behavioral science and refined over decades. The moment you hear any version of, "Do you mind if I look?" that is your cue to deploy the 5 words. Not after you think about it. Immediately and clearly. And those 5 words carry specific constitutional weight. Here's exactly why they work and precisely how to say them so they hold up. Number 3, the 5 words. Write this down. Say it out loud right now so your brain locks it in. I do not consent to searches. 5 words. That is the legally operative sentence that, when spoken clearly and calmly during a traffic stop, creates a hard legal boundary that officers must acknowledge and that body cameras must record. It costs you nothing to say. The potential cost of not saying it is everything. Here is exactly how to deliver it so it holds up legally. First, remain calm. Courts have considered tone and demeanor in assessing whether a refusal was unambiguous. You are not arguing, you are not challenging, you are not making a scene. You are stating a legal position. Calm, clear, and firm. Second, make eye contact. Keep both hands visible on the steering wheel. Speak directly. Officer, I do not consent to searches. Third, stop talking. Do not explain. Do not say because I have a gun in there or my attorney told me to say this or anything else. More words give officers more material to work with. Additional statements can be used to establish nervousness, evasiveness, or unusual behavior, all of which can feed a probable cause argument. 5 words. Period. Fourth, if the officer continues to press, and sometimes they will, you add 1 sentence only. I am not resisting, but I am not consenting. This legally separates your verbal refusal from any physical compliance. If a search is forced anyway, that recorded statement becomes the foundation of your legal defense. Under a ruling called United States v. Drayton and subsequent circuit court decisions, a clear, unambiguous verbal refusal shifts the legal burden entirely. The officer can no longer proceed on your permission. They must now establish independent probable cause, obtain a warrant, or walk away. Your 5 words just change the entire legal landscape of that stop. There's one thing I want to say directly to gun owners who were raised in a generation where saying no to law enforcement felt disrespectful or even dangerous. That instinct is not wrong. It kept people safe in genuinely difficult eras. But here's the truth. In 2026, saying I do not consent to searches is not defiance. It is not aggression. It is a legally protected statement of a constitutional right. And any officer who tells you otherwise is either misinformed or hoping you don't know better. The Fourth Amendment does not require an apology. Use it. But here's the real-world truth nobody wants to tell you. Sometimes officers proceed anyway. And if you're not prepared for that moment, everything you just said can fall apart in the next 10 seconds. Here's exactly what to do. Number 4, the supervisor strategy. There are situations where an officer will tell you they're searching the vehicle regardless of your stated refusal. Sometimes they cite probable cause. Sometimes officer safety. Sometimes they proceed without citing anything at all. And in that moment, the fear and stress of a roadside confrontation can make even the most prepared gun owner freeze. Your goal in that moment is singular. Survive the stop to win in court. Never physically resist. Not ever, not under any circumstances. Physical resistance transforms a Fourth Amendment violation into a criminal assault charge. It eliminates your sympathetic position in front of a judge and jury completely. You will not win a physical confrontation with law enforcement. You will win the legal one. Your voice is your shield. Your documentation is your weapon. Here is the exact sequence to follow. Step 1. Repeat your non-consent clearly for the body camera. Officer, I have clearly stated that I do not consent to this search. Say it again. Be precise. Be composed. The body camera is your witness, and everything on it is discoverable in court. Step 2. Request a supervisor. Say exactly this. I would like to request your supervisor be present before this proceeds. A supervisor's arrival creates an additional witness, an additional camera, and a second officer who must now independently acknowledge your stated non-consent. Supervisors are significantly more aware of department liability. Their presence alone frequently changes the trajectory of the stop. Step 3. Ask professionally for the officer's name and badge number. May I have your name and badge number for my records, please? This single step signals that you are legally aware, that you intend to document this interaction, and that you know your rights well enough to act on them. In many documented cases, this step alone has de-escalated situations that were heading somewhere much worse. Step 4. If the search proceeds anyway, step aside if instructed, keep your hands clearly visible at all times, and continue stating your non-consent for the record. Do not interfere physically in any way. Every word you say is evidence. Every word they say is evidence. Every action taken is evidence. Step 5. Immediately after the stop ends and you are safely away, before you call anyone, before you check your phone, write down everything, exact time, exact location, badge number, physical description of the officer, the exact words used, in sequence, everything that was searched or touched, the order of events from beginning to end. Memory degrades within hours. Write it down immediately. Step 6. Contact an attorney within 24 hours. Not 3 days later, not after the weekend, within 24 hours. In states with strong Fourth Amendment case law, and there are more of them in 2026 than 5 years ago, an unlawful warrantless search can result in full suppression of evidence under what's called the exclusionary rule. That means anything found during that search may be completely inadmissible in court. A case built on inadmissible evidence is frequently no case at all. In 2003, a gun owner in Florida had his vehicle searched over his clearly stated verbal refusal. The officer claimed probable cause based on the odor of marijuana. The gun owner had documented his non-consent, requested a supervisor, and had 3 separate body camera recordings of his exact words throughout the stop. The search was legally upheld on probable cause grounds, but the charges? Dismissed. His attorney successfully argued that the probable cause claim was inconsistent with the recorded interaction timeline. The district attorney declined to prosecute. His firearms were returned within 72 hours. His record stayed completely clean. He survived the stop. He won in court. The supervisor strategy made that possible. Now, what I'm about to tell you is the most urgent thing in this entire video. Because even if you do everything right at a traffic stop, there's a legal shift happening right now in 2026 that most gun owners are completely unprepared for. And it's coming for concealed carry holders specifically. Number 5, the 2026 legal shift. Following a series of state appellate court decisions in 2002 and early 2005, several jurisdictions have formally expanded what qualifies as a furtive movement or a suspicious indicator during a traffic stop. What this means practically on the side of a road with blue lights in your mirror is this: reaching toward your glove box, leaning toward the center console, glancing in your rearview mirror as an officer approaches. Adjusting your seatbelt. Shifting in your seat. Behaviors that are entirely normal and involuntary for any driver are now being cited in some state court filings as articulable reasonable suspicion that justifies extended detainment. These arguments have been accepted by courts. They are on the books. They are being used. Here's where it becomes specifically dangerous for concealed carry holders. Under a ruling called Terry versus Ohio, reasonable suspicion, which is a standard significantly lower than probable cause, allows an officer to conduct a pat-down for officer safety. If you are carrying legally, that pat-down reveals your firearm within seconds. At that point, your carry permit, the legality of your specific weapon, your storage compliance, your magazine capacity, your ammunition type, and critically, whether your permit is even recognized in the state where you've been stopped, all become simultaneous flashpoints. The reciprocity situation in 2026 is more fluid and more dangerous than it's been in over a decade. Several states have modified or suspended reciprocity agreements in the past 18 months. Some changes took effect with as little as 30 days' notice. Online reciprocity maps that were accurate in 2024 may be dangerously wrong today. If you are relying on information that is more than 6 months old, you may be carrying illegally right now without knowing it. In January 2025, a concealed carry holder drove from Georgia into Maryland on a routine trip. Georgia permits are not recognized in Maryland. He was pulled over for a lane change violation. He voluntarily disclosed his firearm, believing disclosure was legally required in Maryland. It is not. Maryland only requires disclosure upon direct officer inquiry. The officer, now informed of the weapon, conducted a consent search. The driver agreed. The firearm was found, transported in a manner fully legal in Georgia, but non-compliant with Maryland's strict transport laws. Class C felony charge, $22,000 in legal fees. His Georgia carry permit was placed under review for 19 months. He didn't know the reciprocity situation. He didn't know Maryland's disclosure law. He didn't know Maryland's transport requirements. And he consented to the search that found the evidence used against him. The solution in 22.6 is a mandatory 3-part compliance check before any drive that crosses a state line, not just your destination state. Every state you pass through, because a traffic stop can happen anywhere on that route. Part 1. Verify reciprocity using a source that is current as of 2026. The USCCA reciprocity map and the NRA ILA state law database are both updated regularly. Check them within 2 weeks of any interstate trip. If you travel frequently, check them monthly. Part 2, verify transport laws for every state on your route. Safe storage requirements vary enormously. Some states require firearms to be unloaded and in a locked container stored separately from ammunition. Others allow loaded transport in a locked container. One state's compliant transport is another state's criminal charge. Part 3, know your disclosure obligations state by state. Some states require immediate disclosure at every traffic stop. Others only require it when directly asked. Others have no requirement at all. Getting this wrong initiates a legal cascade you cannot stop, and in every single state, for every single stop, regardless of what you're carrying, where you're going, or how cooperative you want to be, the same 5 words apply. I do not consent to searches. Let's bring this together. You came into this video because you want to know how to protect yourself at a traffic stop. Here's what you're walking away with that most gun owners in 2006 still don't know. 1. The consent trap. Your Fourth Amendment protection disappears the moment you say yes. Officers aren't required to tell you that you can refuse, and every consent you give creates a legal record that follows you. 2. The psychological pressure play. Nothing to hide phrases, statement-framed questions, and odor-based probable cause claims are trained consent elicitation techniques. Recognizing them is the first step to not falling for them. 3. The 5 words. I do not consent to searches. Calm, clear, and immediate. No elaboration, no explanation, no apology. 5 words that the Fourth Amendment backs completely. 4. The supervisor strategy. If an officer proceeds despite your refusal, request a supervisor, document everything in writing immediately after, never physically resist under any circumstances, and contact an attorney within 24 hours. The stop is not where you win. The court is where you win. 5. The 2026 legal shift. Reasonable suspicion standards are expanding. Interstate reciprocity is actively shifting. Disclosure laws vary by state. Verify all 3 before every interstate drive using sources updated in 2026. not 2023. Any one of these points handled incorrectly could cost you thousands in legal fees, your carry permit, or your permanent lifetime right to own a firearm. Any one of them handled correctly could be the difference between going home that night and not. If any of that felt complicated, that's exactly why this channel exists. Gun laws don't stay still. They shift, they expand, and they do it quietly. I break down the changes every single week so you can carry with confidence and know exactly where you stand before you ever need to. Subscribe so you're never the last to know when the law changes. Next video, 5 states where concealed carry permits are suddenly dead in 2026. And if your state is on that list, you need to know before your next drive. Don't miss it.